Federal judge blocks Trump administration from using Alien Enemies Act to deport Venezuelans. In a major legal rebuke to the Trump administration's immigration strategy, a federal judge in Texas has permanently barred the government from using the Alien Enemies Act, AEA, a law dating back to 1798, to deport Venezuelan nationals from the Southern District of Texas. The ruling, delivered by Judge Fernando Rodriguez Jr., a Trump appointee, is the most sweeping to date among several challenges to the administration's controversial effort to invoke the rarely used wartime statute for modern immigration enforcement. The case stems from the administration's attempt to target members of the Venezuelan gang Tren de Aragua, TDA, which the FBI has claimed is part of a broader effort by the Maduro regime to destabilize the United States by exporting criminal elements. President Trump has repeatedly described illegal immigration as an invasion and used this rhetoric to justify invoking the AEA, originally intended for use during wartime or actual military invasions. However, Judge Rodriguez's 36-page opinion ruled that such a justification does not meet the legal threshold required under the AEA. The court concludes that, as a matter of law, the executive may not rely on the AEA based on the proclamation to detain the named petitioners in the certified class, nor to remove them from the country, he wrote. Rodriguez emphasized that terms such as invasion or predatory incursion, as used in the 18th century law, refer specifically to military actions, not gang activity or unauthorized migration. The ruling not only strikes down the administration's use of the law in this particular district, which includes major cities such as Houston, Brownsville, and Laredo, but also sets a precedent that could affect similar cases nationwide. Earlier, the Supreme Court had ruled that individuals targeted under Trump's AEA proclamation must be allowed to contest their removal. Judge Rodriguez's decision goes a step further by declaring the administration's application of the law entirely unlawful in the current context. Despite the ruling, the legal battle over the AEA continues. The ACLU has won temporary halts on new deportations under the Act, but has not yet succeeded in securing the return of approximately 140 Venezuelans who were flown to El Salvador on March 15th. Those individuals are currently being held at the Center for the Confinement of Terrorism, CECOT, a high-security facility known for its strict conditions. In Washington, D.C., ACLU attorneys have petitioned Judge James E. Boasberg to order the federal government to bring those deported back to the United States for due process hearings. Their request cites a recent Supreme Court ruling in the case of Kilmar Armando Abrego Garcia, in which the justices emphasized that the government must facilitate the release of deported individuals if removal was unlawful. The Justice Department is expected to oppose the ACLU's motion, with filings due by the end of the week. Meanwhile, the White House has yet to issue a response to Judge Rodriguez's decision, though it continues to pursue a separate case before the Supreme Court to revoke Temporary Protected Status, TPS, for more than 350,000 Venezuelans currently living in the U.S. That move was blocked by a lower court, setting up another potential flashpoint in the administration's immigration agenda. As legal scrutiny intensifies, the fate of thousands of Venezuelan immigrants hangs in the balance, caught between constitutional interpretation, executive power, and the humanitarian realities of displacement.